Yes, ma'am.
Good
Yes,
evening to everyone present here. I, Avneet Kaur, member of Sambhav Initiative and moderator for this event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Mrs. Mrunalini Deshmukh ma'am, and to all the participants in this 2 weeks National Capacity Building Program on Family Laws, Court Practice, Procedure and Drafting, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, and creating legal literacy among different groups of society under the vision and direction of Patron-in-Chief of Sambhav Initiative, Honorable Justice C.K. Thakkar sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice M.R. Shah sir, former Judge of Supreme Court of India, in collaboration with Pro Bono India, which is working towards legal aid and legal literacy, where today's session is all about divorce under Hindu laws and Special Marriage Act. It is my distinct honor and privilege to introduce Advocate Mrunalini Deshmukh ma'am. With over 2 decades of distinguished legal practice, ma'am is widely recognized as a pioneer in family law in India. Ma'am commenced her legal journey in 1981 under the mentorship of the then Advocate General of Maharashtra, Mr. Arvind Bobde, after completing her LLB from prestigious Common Law College, Mumbai. Ma'am has appeared before courts across India and has been instrumental in several landmark judgments related to maintenance, child abduction, and relocation. Ma'am has built a formidable reputation as a counsel for high profile clients, including leading businessmen, professionals, and celebrities. In addition to her thriving practice, Ma'am is a passionate advocate for women's rights and has spoken at numerous national and international forums on family law, wealth structuring, and alimony. Notably, Ma'am has addressed the International Conference on Wealth Planning for Global Indian Families in Dubai. Her international footprint in family law is exceptional. Ma'am has provided expert legal opinions and appeared as an expert witness in courts across USA and Australia, including Boston, New York, Florida, Sydney, and most recently Ohio in 2023. Beyond litigation, ma'am has also contributed to academia as a professor of constitutional law and visiting faculty at Mumbai University. Ma'am is the author of book Breaking Up: Your Step-by-Step Guide to Getting Divorced, published by Penguin. In recognition of her outstanding contribution to international family law, ma'am was appointed as Fellow of the International Academy of Family Lawyers in 2025, the first lawyer from Mumbai to receive this honor. We are deeply honored to have you with us today, ma'am. Over to you, ma'am.
good evening, everybody, and thank you so much for inviting me and making me a part of this which I suppose going to be very interactive and a great audience who are sort of very eager and very curious to know a lot about the subject that I'm going to speak on. So thank you for inviting me. Thank you for making me a part of this great evening. And apologies for logging in a little bit late due to certain prior commitments. But having said so, I'm very happy to have a conversation with you and share my experiences and a little bit of my knowledge that I have gained during the course of my practice and would like to share that. Now, interestingly, you have to understand, and most of us know that, and I think we shall weave in some other projects like, and concepts, which I will say when we go through the course of the thing. Our laws are marriage, divorce, child custody, succession, inheritance, as we call it, all are based on our personal law. So I'm sure there are law students who know all this. So we are governed by the faith of the religion that we are born into. So for example, if I'm a Hindu, I'm governed by the Hindu Marriage Act. Somebody's a Christian, somebody's a Parsi, and so on and so forth. So these laws of marriages and divorce that we are talking about are not the laws which are uniform for all people. Most of the provisions are overlapping, most of the provisions are common. But if you go to see that they have their own nuances and they have their own sort of, intricacies that they deal in. Now, having said this, we have to, the subject that has been appointed or given to me is basically the laws of marriage as far as the Hindu marriage is concerned and the Special Marriage Act is concerned. So I will sort of divide only these concepts and restrict myself to the submissions or to the points which are relevant for this subject. Having said this, that Hindu Marriage Act and Special Marriage Act, let's come to the Hindu Marriage Act. Now, when I say that people from a particular faith, when they get married under the act, that act is an act which governs their personal issues of marriage, divorce, custody, inheritance, etc. But the Special Marriage Act, just to give you an example or to give you a parallel, is a law in which, in common, I would say, in common parlance, we could call it something which is known as a secular law. Now, why is it a secular law? Because under the Special Marriage Act, any two persons, and the word is persons, okay? So any two persons under the act can get married provided they follow what the procedure is. The religion of the person is not important. Now, just to give you a little, to stray a little bit from here, because you're all law students and students of law like you and me need to understand that in the Supreme Court there was a couple of years back a petition that was filed for the marriages of the gays and the lesbians and LGBT. They said that the Special Marriage Act, and why I'm giving you this example, one of the arguments that were put forward is that why would a Special Marriage Act would be something which could be applicable in the event the law were to permit the marriages between two people who were either gays or lesbians and so on and so forth. They said the Special Marriage Act says any two persons. Where does the act say it has to be a man and a woman? Or where does it say, why cannot be two men? Why cannot be two women in case they want to get married? So this was a constitutional debate that was going on. And the reference I'm giving you for this was only to understand that how the Special Marriage Act is a unique act in itself, where two people or two persons, to use the word that is used in the enactment, of two faiths, different faiths, can get married under the act, and still that marriage could remain to be a valid marriage. Now, why am I saying this, that they can do this, and why is it if I go to see the Hindu Marriage Act? Now, under the Hindu Marriage Act, the law says that if you see Section 2 and onwards of the Hindu Marriage Act, is that only two people who are Hindus, they can get married under the act. So what happens if one person is a Hindu and the other person is a non-Hindu, let's say Christian or a Muslim or whatever it is? What is the status of the marriage of a Hindu and a non-Hindu if they are married as per the Hindu Marriage Act? Now, pausing here for a moment, we have to understand what constitutes a Hindu marriage. Okay? Hindu marriage under the uncodified law before 1955 and post the codification of the law in 1955 says that Hindu marriage is both a sacrament, please understand, a sacrament and a contract. What does a sacrament mean? It means a religious touch, which means there are feras, as we know, which means there are certain kanyadan, certain essential ceremonies to be performed. So Section 7 of the Act talks about the essential ceremonies which need to be performed to make it a valid Hindu marriage. So that is the sacrament part, the sanskara part of it, which has been retained by the Act even after the codification of the Hindu Marriage Act, which was in 1955. Prior to 1955, it was obviously a religious and an act which was also upheld by custom that people were to get married, and these were the reasons that why they needed to get married. So today, even after the codification, the marriage has been made both a sacrament and a contract. Now, why am I saying it's a contract? Is it a Muslim marriage that I'm saying it's a contract? No. Contract means any two people who are of an intelligible age, who are adult and who understand what it is, are the only persons who can get married. And that has been captured, that is the age of the girl or the bride-to-be has to be minimum 18. And the age of the bridegroom or the boy has to be 21. So when let's take the example, when an 18-year-old and a 21-year-old decide to get married, whether they are eligible in law to get married, the answer to that question is yes, they are. because they can make a valid contract. So a Hindu marriage is both a sanskara or a sacrament and a contract. And the Hindu Marriage Act applies only to the Hindus. So the question that I put to you is, what happens if a Hindu and a non-Hindu get married? And they go through the ceremonies, they have that big fat Indian wedding, they go through fairas, they go through kanyadan, etc. But the bride is a Christian. Will that tantamount to a Hindu marriage? The answer is no. How can I have a valid Hindu marriage if I'm not a Muslim, if I'm not a Hindu at the time of marriage? So there is a provision which talks about conversion. So if I'm a Muslim girl and I want to get married to a Hindu man, I can convert myself from my religion. And after I get converted, I become a Hindu, and then I can be legally in a state to get married to the person. So you understand these nuances. So the Hindu Marriage Act is applicable only to Hindus. A Hindu valid marriage is only between two Hindus, and it cannot be between a Hindu and who is not a Hindu. The Hindu is defined, or it's expanded to include Jains, to include Buddhists, to include Sikhs. So all these constitute a Hindu, and all these are the parties who are governed by the Hindu Marriage Act. So that is the basic essential of that. When you go to a situation where a marriage is valid, that's fine. What is it that makes a marriage invalid? Or what is it that makes a marriage void? What is it that makes a marriage voidable? Are the questions that need to be looked into before we get into the grounds of divorce, etc. So for the annulment of a marriage, or to declare the marriage null and void, what is null and void? That means it has not existed from its inception. That is what null and void means. Okay. So if a marriage, what is a marriage which can be declared null and void? A, it has been given in section 11 and 12 of the Act, which says that in the event the marriage solemnized was not consummated owing to, say, the impotency of the husband or the wife, then such a marriage can be annulled by a court of law. And that is retrospectively from the date of the marriage. So it is void ab initio. Similarly, the other grounds which have been given, that what happens if the woman is pregnant from some other person at the time of marriage. So she's pregnant with A. She gets married to B. At the time when she gets married to B, she's pregnant from A. Such a marriage, if the husband wants, can declare it to be, a void marriage. And if we are able to prove that a fraud has been committed on one of the parties at the time of seeking his or her consent, and if you are able to establish that fraud, then even that marriage can be annulled. Now, what is fraud? Fraud as to the nature of the marriage, fraud as to some of the essential requirements of the marriage, and some of the essential commitments to the marriage. For example, what happens if a person is an alcoholic, or is of an unsound mind, and has been to rehab, has been to all those things, and these facts are not known to the girl prior to marriage? What happens? Can she go on the grounds of fraud? So these are certain things that the courts will have to examine. Not each and every of these instances amounts to fraud as understood under the Hindu Marriage Act. To understand the definition of fraud, you have to go back to the Indian Contract Act, which defines what fraud is. But we will not get into the details right now, because we have a lot of things to cover during the course of this interaction. So there is a void marriage. Then there is a void marriage is also, so these are voidable marriages, which I discussed. A void marriage is one where there is a monogamy is the rule of the law. So prior to the codification of the law in 1955, a man could have more than one wife. Okay. And that was completely legal and completely acceptable. However, after the codification of the law, and when the law came into existence in 1955, it has upheld monogamy, that is one man, one woman relationship, as a valid marriage. Now, if that is a valid marriage, and suppose if the person whom A is getting married to B is not a single person, or is not a divorcee, or is not a widow in case she's a woman, but is a married woman, then that marriage between a bachelor and a woman who is married, or vice versa, it could be the woman is single and the man is a married man, could be because bigamy is not recognized as the law in the Hindu Marriage Act. Though, as I said, prior to the codification of the law, Hindu marriage and the Hindu Marriage Act coming into existence, the man could have more than one wife. A typically very patriarchal society, so man could have two wives, but a woman could not have two husbands. So that was not acceptable. So, this kind of setup, and this has been led to a lot of discussions and debates by the lawmakers at the time of why Hindu code, why the codification required, why can it not go as per what the laws has been there. All these debates have taken place. So you have a valid marriage, you have a void marriage, you have a invalid. Now, that's okay. These are the different categories and things which are there. People get married, they take vows before the holy fire, and they expect that they would to be together without using the words, but as the Christians say, still death do us apart. So marriage was supposed to be a very indissoluble, that is that which cannot be dissolved, kind of a situation, because marriage was meant for keeps, for lifelong. You were married for lifelong. As some of you may be knowing, that the ancient Hindu said that this is for the 7 lives. Saat janam ka rishta is what you may have heard about it. So these are the kind of philosophies that come around the Hindu Marriage Act. So that is why divorce was something which was very, it's looked down upon, not really something that was sort of, talked about, unlike today when we are talking about it. I'll come to it a little later. So what they did was that there was only what is known as a fault ground of divorce. Okay, so fault kind of divorce is what? One of the parties to the marriage, either the husband or the wife, so it was a gender neutral, so either of them could seek the dissolution of their marriage if there was a fault of the husband or the vice versa. And what are those faults? Those are the grounds of divorce, which you will find in section 30. So number 1, adultery. A is married to B, but during the course of the marriage, B enters into an adulterous relationship. If B is a husband, then with another woman, or if B is a woman with another man, during the course of the marriage. And this is not acceptable to me. So this is a valid ground of divorce. So adultery. I'm sure many of you as law students will realize that adultery earlier was also a criminal offense, 497 on the earlier, in the earlier IPC before the BNS came into existence. And that was a criminal offense. So what was that offense? So if a husband and wife are there, and if the wife has an adulterous relationship with a man, her paramour or her boyfriend or whatever you call it, then the husband had also a recourse not only to go for a divorce against his wife, because that was a valid ground of divorce, but he also had recourse to go against that man by filing criminal proceedings under the old IPC 497, charge him with the charges of adultery. But the law was such that the wife can be only said to be an abettor or somebody who helps in the commission of the crime, but not to be charged with adultery under the Criminal Act. Have you understood the difference? What it said was that a husband could file criminal charges against the adulterer, which is the paramour or the boyfriend. But the adultery has been committed by the wife also, right? So it is consensual sex that the wife had with that man. But the wife was absolved of that. And it was made to believe by the lawmakers at that point of time that the man, the boyfriend, I'll call it for the lack of better word, the boyfriend enticed her, lured her to getting into sexual relationship. And though she voluntarily got into it, she was absolutely very, what do I say, very naive and not aware of what she's doing. So that is what was challenged in the Supreme Court of India, and which we find in the judgments of China, where it says that it is no longer a criminal act that has been done, but the civil recourse has also to be taken, which is the divorce. Now, sorry, coming from this, I don't know how many of you have read in the newspapers that the Delhi High Court, in one of the matters, okay, where there was adultery or inappropriate relationship or affairs, as we would call it, there was a claim that was made by the wife against, so wife had filed for, say, divorce or whatever the case may be, because the husband was in an adulterous relationship with one Miss X, okay. So the wife raised this issue before the Delhi High Court, saying that, okay, it will give me a divorce, it will be a good ground for divorce, but why would I, as a wife, allow the person who is Miss X go scot-free when she is equally responsible for causing me grief, agony, breaking my home, or whatever it is? So the Delhi High Court, in one of the cases, has sought replies, and it's still pending. So the matter is still sub judice. So I'm not giving you an opinion of what is sub judice. I'm saying, see how the law has progressed, how the law has traversed all those conservative, traditional, straitjacket ways of looking at it, and has become very progressive and is galloping at a very fast pace. So the courts have now raised a point based on the contention of the wife, whether any compensation is available to the person, that in this case, in the Delhi High Court, the wife, whose husband had adulterous relationship with X. So adultery is one of the grounds which was there, or which is there today in the Hindu Marriage Act. The other ground which is available for a person, and this is all under the fault theory of divorce. When I say fault theory of divorce, I will say that when I give you the other theory which is available. But right now, let's concentrate on the false theory of divorce. The second ground is cruelty. Now, what is cruelty is not defined in the section. It just says that an act of the husband or the wife, as the case may be, which has caused immense grief and agony to the applicant, whether it's the husband or the wife, that it is impossible for him or her to continue to live with him or her for the next whatever few years or more years of their life. So the cruelty was a ground that was taken. Now understand one thing. Traditionally, or I would say historically, cruelty was always looked upon as a physical cruelty or physical violence. The wife has been beaten up, the wife's hands are twisted, turned, the wife is bashed up, the wife has been doing all this physical cruelty. But later on, by how do I say, judicial pronouncements, and when different kinds of matters came up, for the first time, the question, or not question, the concept of cruelty was expanded and was enlarged to include not only physical cruelty, but also mental cruelty, emotional cruelty, cruelty to such a nature that it is causing harm to the person concerned. That's point number two. I'll come to what all constitutes. Now, in physical cruelty, probably the easiest thing is to show that when he has hit you, or you've got bruises, you've got medical records, you have got hospitalization, you have prescriptions, etc., to prove, and a police complaint to show that such a kind of cruelty, physical cruelty, was perpetrated on you. But the mental cruelty that we are talking about, or the mental violence that we are talking about, the question that arises is that how do you prove it? And what is mental cruelty? It's easy to use these fancy words, but what does it mean to use, or what does it mean? as we talk about mental cruelty. So I'll give you a few examples that will make the understanding very distinct. And this is one of the classical case laws which was decided by the Supreme Court. I think it's AI 1975 Supreme Court, and I'm subject to correction, which is Dastani versus Dastani. It's one of the classical landmark judgments, which has not only sort of shaped the jurisprudence of divorce and the grounds of cruelty, but has also given an insight into how can there be a solution where there is no physical hurt to the person, but the behavior of the other spouse is causing so much of grief and agony that it is leading to that. Now, what was Dastani's case? Let me just tell you. Dastani's case was that there was a doctor, he was married to a lady. The lady had some mental health issues, as a result of which her behavior was very violent, very aggressive, and she could do that. In fact, if you read the judgment, it's a very well written judgment by Justice Y.V. Chandrachud, who was the father of the ex-Chief Justice of India, just Dr. Dhananjay Chandrachud. And this is the judgment penned by him in the Supreme Court, and which has now, in a way, laid down the law. And it said that they've given instances. The wife, due to her mental health issues and her aggression and her things, was causing him a lot of pain. For example, what she would do is, I'll tell you, and sound very, she was not all there, she was not balanced. She would take the child, and it's written in the judgment, and take chili powder and put on the tongue of the child. The child would howl, the child would scream, and then she would just trouble her husband by seeing that the child is tortured, because she had a lot of mental health issues. Some people do it because of mental health issues, some people do it out of vengeance, some people do it for whatever reason. So this is the kind of example which was brought to the notice of the court, that this lady has not caused me physical harm. So cruelty classically doesn't come there. But her behavior, and one of the instances was this. Or she would go, whenever he went to the room, she would just shut the door and lock it and go out of the house. Now, what was it? A doctor who had to go to the hospitals or who had to go to see his patients was unable to get out of the house because he was locked in his own house, because that's what his wife did. Now, once it can happen, twice it can happen, but if it becomes a pattern, obviously it is going to be impossible for the man to live with her. So these are the kind of instances that were brought about to the court, to the attention of the court. And the court at that point of time, if you read Dastani versus Dastani, you will realize that the court came out with an expansion of the definition of cruelty to include even mental cruelty. What are the other examples? This I gave you an extreme example. The example was to drive home the point. What are the other examples of cruelty? For example, and I've seen this in many of my cases, and this is recent phenomena where women are now studying, working, they become entrepreneurs, they have become achievers, and they do that. There are certain kind of husbands who are control freaks and do not like their wives to be with them. For example, there is a lady who is a young, attractive lady who has worked hard, who's managing the home, who's attractive looking, and she's well dressed and she's growing. The husband constantly accusing her of saying that, oh, you're not going out to work, you're going out to impress men, you're going to solicit some kind of things. Now, for a respectable woman to be addressed in such a manner, let apart you acknowledging or accepting that, wow, what you're doing is so great, you're managing my house, you're managing your career, you're making money, you're making name, you're making a dent in the profession that you are. Forget all that. What does he do? And these are life cases that I'm talking about. He tries to demean her by saying that you are doing this. Your character is very loose. You have no talent. You have no ability. You're just using your body, or you're using your face, or you're just objectifying yourself to get whatever your things are. Now, this is extremely demeaning for a lady to hear that. One day, twice, third, three, four times. There is a limit to which she can take it. If it becomes a daily phenomenon, can there be any cruelty worse than this? That you are day in and day out told that this is what you're doing, that you're worth nothing, You have no brains, you have no talent, you have no capability, but only because you have a good body and a good face, you are doing this. So this kind of erodes the self-worth of the woman. And I'm taking a woman as an example. It could work the other way around, and I'm going to give you that example also. It erodes the self-worth of the person. It humiliates, embarrasses her, and is causing her a lot of grief and mental agony. It's causing her pain. That pain, the law captures as mental cruelty. If I flip it, that husband, better, he's doing, he's struggling, he's working hard, he's doing this, he's trying to do, but is unable, but is unable to get a foothold into the profession, or is unable to make money, or is unable to run his business or do that. To ridicule him constantly, to shame him that you are good for nothing, you're a loser, you can do nothing in your life, and you can do this kind of thing, which becomes a daily pattern, also amounts to mental cruelty to the husband. So I'm just giving you these two uh, divergent examples to prove that what could be mental cruelty. And there are various other examples also which are there. The Supreme Court in the sort of over a period of time, when after dealing with these cases of cruelty, has been able to expand what amounts to cruelty in Samar Ghosh's case law. And they had given for the first time the different breakups or the points which we are talking about are what constitutes cruelty. And so the journey of the concepts, and I would say grounds, etc., has started in 1955, but has grown over a period of time more by judicial interpretation, more by judicial activism in some cases, and more by understanding the social-legal impact it had on the institution of marriages, on the institution of the man and the woman, on the dignity and the self-respect of the woman. So these are the things that have been sort of, expanded and used. Point number one. Point number two, that in cruelty, one has to understand that cruelty cannot be put into words, cannot be put into expressions. It is the feeling that one person gets over a period of time because of the conduct or behavior of the other person. That is what is captured by law. That is what is understood by law. That it can be, it's like a Chinese torture. Every day it's being done on you, day in, day out. How are you supposed to do that? There are some people who cannot take it. Some of extreme cases, they end taking up their life. There are some cases where people just suffer because they have no option. These are social reasons. Uh, the concept is, oh, once you're married, you're there for lifetime. The parents don't welcome you. Today, of course, it has changed a lot. I'm talking about in the initial stages. And lastly, and more importantly, what is important to know is that this concept of cruelty has been now appreciated by the courts to mean that which causes extreme pain and agony, and which a person feels useless about oneself. Self-worth is gone, self-respect is not there, and you are driven to that point. That is also a ground which is recognized by law. So cruelty is the other part. Thirdly, more importantly, is the ground of desertion. Now, you have to understand one thing very. Can you just give me a minute? I'll just get some water, please. Thank you. Sorry for this. The fourth ground, which is available under the existing laws of divorce, are what is known as desertion. Now, desertion, you have to understand, it's a very, how do I say, you have to understand what desertion means as in law. Normally, what people say is desertion is something that, somebody has left the house. Oh, I get clients who come to me and say that, ma'am, my husband has left me, he's deserted me, and he's gone. So, can I file a case under desertion? So, physically leaving the house is not desertion. Desertion is when, for a continuous period of 2 years, the person is either physically separated or has not performed any of the duties that is expected of him to perform, thereby deserting the person by negligence, by abandoning emotionally, by not having any physical relationship. And this has to be a continuous period of 2 years. That amounts to desertion, as you can. So, desertion is not only a physical thing, but is a something which is withdrawal from the state of these things that are happening. So you could be in the same house, and that could be desertion, or you could be physically away and there could be desertion. That is the next point that is there, and I'll give you some little examples of that case law when I finish this. The fifth ground that was available is unsoundness of mind. Now, what happens if one of your spouses, as I said in the example that I gave you, dastani versus dastani, what happens if one of the spouses is having a mental health issue? He or she has got depression, they're bipolar, schizophrenic, some of them, extreme cases of aggression, violence, etc., happening to the mental health issue. Now, you cannot be expected to live with a person like this who has got these issues, which is affecting your mental, your physical, and your well-being. So, is that a ground that you can go for divorce? The answer is yes. But what is that mental health which can constitute a ground for the husband or for the wife to go has to be defined and understood in the facts and circumstances of the case. It cannot be a straight jacket, oh, he's got schizophrenia, so it's a mental health issue. So it has to be taken in overall thing. And lastly and importantly was those days there was this leprosy and some sexually transmitted diseases or some of these things which were there. They were also presumed to be a ground for a valid divorce. So these are the different grounds of divorce. Now you have to understand one thing. This was the fault theory. So listen, I am the applicant, you husband are guilty of A, B, C. Cruelty, desertion, or unsoundness of mind, or leprosy, or sexually transmitted diseases, and so I want. The legislature came with a suggestion or a thought, and there was a lot of mental pressure, or sorry, a social pressure that was building up. What happens if two people are not getting along? Do I have to prove that the other person is wrong? Do I have to say he's cruel? Do I have to say that he's deserted me? Do I have to say he's a mental health issue? We are two good people, but we are not getting along. We are not compatible. And there is no provision in the law. So the law was amended in 1976, whereby, for the first time, the concept of divorce by mutual consent was introduced in the Hindu Marriage Act, where they have laid down the terms and conditions. What are the terms and conditions that who can apply for a mutual consent divorce? Number one, parties have to be married at least for a period of 1 year. Number two, the parties have been living separately for a period of 1 year prior to the filing of the petition. The parties had jointly filed an application saying that we are married for more than 1 year, we separated for more than 1 year, and we have tried everything and we are not able to live together. Jointly make a statement to the court that they want a divorce. After the filing of the divorce, a 6 months cooling off period or waiting period is given to the parties. The reason for giving this is that no court, no legislation, no lawmakers want marriages to break easily. So they want to ensure that sometimes people in a fit of rage or a fit of anger or a fit of reaction go and file, or go and say, okay, we are not getting on, let's go and file a divorce. Then maybe they think after a week or 10 days, what did I do? I mean, it was a stupid thing to do to go and file for divorce. So that option is given for them to withdraw the petition. saying that we want to live together or we want to work out the marriage. And after this, in a given situation, the couple has jointly filed a petition. They have stated on oath that they are staying separate for more than 1 year. They have stated that they have not been able to live together. They have stated that we tried to work on the marriage 6 months, even after the filing of the petition, but it did not yield any result. If all those categories are there, then the courts will grant the divorce by mutual consent. This is captured in section 13(13)(b), capital B for Bombay, of the Hindu Marriage Act. Please understand one thing. Earlier, there was only a fault here in 1955 when the Act came. It was in 1976 that a mutual consent was incorporated. And that's the thing, that today, if there are two people who are married and they fulfill all these conditions and they don't want to live together, they don't have to go down the route of blaming each other, you did this and I did this and I did this. They can say, as we say, two good people in a bad marriage. So this is the most dignified and the graceful way of getting a divorce, which was now introduced in the law, in the statute in the year 1976. One more change that came about in the Hindu Marriage Act was that the law was again amended to include. Okay, before I come that, let me just tell you. A divorce petition, you're all lawyers and law students. A divorce petition you have to file under Hindu Marriage Act. Where can you file? Which is the jurisdiction? That you will find in section 90. What does it say? The place where the parties got married, number one, or the place where they last resided together as husband and wife prior to their separation. Thirdly, where the respondent resides. The petitioner may reside anywhere, but he could file a petition in a place where the respondent resides. So these were the only three conditions which are mentioned where the courts have jurisdiction. But after the amendment was made, they have now introduced a clause that the wife can file, even if she does not fulfill those three criteria. She can file a petition from the place where she resides after separation. So the parties, let me give an example. The parties may have got married in Delhi. The parties may have last resided as husband and wife in Bangalore. Okay. The husband resides in, say, Cochin. Okay, these are the three places that she can file. But she is residing in Mumbai to be with her parents. Does the Mumbai court have jurisdiction? Answer is yes. If the Mumbai courts find out that she has been residing here for whatever reason, after separation, or she was thrown out of the house, or whatever the case may be, then she will be well within her rights to invoke the jurisdiction of the Mumbai courts for her relief. Some of you may be also knowing what happens if the husband files a petition, the same case that I've given you. The husband files a case in, say, Bangalore because the parties last resided together as husband and wife in Bangalore. But the wife is living in Mumbai. She has nowhere to go. She does not have money. How can she fight a petition in Bangalore when she's staying in Mumbai with her parents at the mercy of her parents? There is a provision in law where under section 25 of the Civil Procedure Code, the wife can seek transfer of the petition filed by the husband and vice versa. When I give you these examples, please understand it's a gender neutral. I'm just giving you for you to understand better. The wife can sort of seek a transfer of the petition where the husband has filed or vice versa to a place where she is currently residing. And the Supreme Courts are entertaining if they are between two different states, say Maharashtra and Rajasthan, it will go to Supreme Court. But in Maharashtra, let's say in Gujarat, it is Ahmedabad and Baroda. It will go before the Gujarat High Court. Okay, so that's how the jurisdictions are determined. So that's the way that happens as far as the grounds of divorce are concerned. I've also said what is a mutual consent petition, and I've also told you what is a valid and how would I say a null and void marriage. Now, having said this, I would just like to say that the Bombay High Court, so in fact, there was one judgment as when we were doing cruelty, which is Vibhor Garg versus Neha, 2025 Supreme Court online it is, which is authored by Justice Nagaratnam, wherein it was decided only in July of 2025, where the court emphasized, and please hear every word, that spousal communication were deemed privileged under 122 for the purpose of protecting the sanctity of the marital relationship and not for safeguarding individual privacy rights. Now, what had happened is in this case, I must tell you that there was some conversation which was recorded by one of the parties, like audio, like how this thing is being recorded, right? What I'm speaking right now. Today, with everybody has phone, everybody has facility of recording, etc. Recorded certain private conversations or recorded certain things and introduced that in a court of law. The other side, against whom that was there, objected to it and said that this is invasion of privacy. How can you record? How can you do this and produce this as evidence in a court of law and use it against me? It was in that context, this judgment, which is Vibhor Garg versus Neha, it says that spousal communications were deemed privileged under under section 122 of the under section 122 for the purpose of protecting the sanctity of the marital relationship and not for safeguarding individual privacy rights. Why did it come under privileged communication? Because it was only to take care of the sanctity of the marriage. But you cannot use that if it is going against the sanctity of marriage to be able to exercise only your personal rights. So that is the latest judgment which has come up on the ground in cruelty also. The other judgment which I would like to draw your attention is Rupa Soni versus Kamal Narayan Soni, 2023 Supreme Court, in which the court said that what is cruelty for a woman in a given case may not be a cruelty for a man, and hence a relatively more elastic and broad approach is required when we examine a case in which a wife seeks divorce. The court said historically the law of divorce was predominantly built on a conservative canvas on the basis of fault theory. However, with the adoption of a libertarian attitude, the grounds for separation have been construed in accordingly. So this is how the law has developed of cruelty, from physical cruelty to mental cruelty. Now, in cases which were there regarding, there are a whole lot of cases which have been given, but I think now, so Prachi, are you the coordinator?
Yes, ma'am.
And what is the time I have right now?
I think you can complete the.
Okay. No. What is the time frame I have? Because I don't know exactly.
We can start. We can stretch till 8:30 if you want. Am I right, sir?
Ma'am, like maximum 15 minutes will be fine because ma'am will be having again. Ma'am, 10, 15 minutes if you are okay.
Yeah. You tell me how much, because I can
Yeah,
do
sure.
as much. I mean, as much as we want. So you have to tell me what is it.
Yes, sir. Participant, any question query you can ask, ma'am. You can raise your hand. So it may be interactive in the last portion of this particular session.
So right now, I want to deal with another aspect, and that aspect is also under the Special Marriage Act. Okay.
Yes.
So let me complete that part of it, because I think that's one of the things that I need to cover. I've been only talking about the Hindu Marriage Act and this Special Marriage Act. I'm going to get into a very specific thing. Number one is Special Marriage Act, as I said at the beginning of my lecture, is where any two persons can get married and they will be governed. What is the procedure? Procedure is laid down. They have to approach the marriage registrar in that area. They have to give a 30-day notice and say they cannot get married before the expiry of the 30 days. And also, more importantly, that within the period of 30 days, either of the parties can withdraw their consent for the marriage or for whatever reasons it is there. The life of the thing is for the next 90 days. So you have given and then you can get married. This is known as what we normally call, or in colloquial language, what we call is a court marriage. Somebody says, no, no, this was a Hindu marriage, and the other thing says that it was a court marriage. There is also provision under the Special Marriage Act, when you see, where registration of marriages performed in by any other ceremony can be registered here. Which means if there are two people who have got married under the Christian, say church marriage they can register their marriage under the Special Marriage Act. But the law says that you are governed by Special Marriage Act if you get your marriage registered there. Similarly, Hindu marriage or so on and so forth. The grounds for divorce, the grounds for annulment, the grounds which are there are more or less similar to what the Hindu Marriage Act is. And more importantly, what is important is that this is known as a secular law of marriage, because it does not consider caste, religion, anything of the parties. It only says the willingness of two people who are adults, of course, and who want to get married. Is point number 3. Point number 4, in case of Special Marriage Act, in case of Hindu Marriage Act, which I have not gone because that's a separate topic that will be taken up by some other speaker, that these acts are so inbuilt and so comprehensive that they don't only have the grounds of divorce and annulment and valid, invalid, or not valid, avoidable, and void marriages, but they also have inbuilt concepts of child custody if there's a child born from the marriage. What are the rights and what are the etc. The law regarding that. They have also inbuilt what is known as maintenance or support for the wife or for the children. Remember, one thing very interesting is the Hindu Marriage Act and the Parsi Marriage Act are gender neutral, which means under this act, even the husband can claim for maintenance. The husband can claim for alimony in some given cases where it comes to his knowledge that or where he's unable to maintain himself. So these are very gender neutral things. So these are the kinds of laws, and they have all these inbuilt provisions also. So what is really important in this that you have to say? Now, one last question, one last point that I'm going to, and I want you guys to debate on it, and I'm going to give you my views a little later. Do you think with so many issues that happen that Uniform Civil Code is an answer? I want you to use your thinking caps and let me know. Number 2, we come across marriages where a Hindu and a non-Hindu get married. What do? We have to make a declaratory suit. We'll come to all those points maybe at a later stage when you have it. But these are the different nuances, and I think I have really crossed my sort of time that is there. That's what happens. There's so much the law says. There's so much that the law entails. There's so much that the courts have interpreted the law. So what was the law in 1955, 1956 has really, really expanded and grown into a very massive thing. So these are the various instances that we see of the marriage. Then, and last one thing that I want to show is that as the number of cases increased and people saw that there were huge volumes which were there as far as divorces were concerned, custody was concerned, a special enactment came into existence in 1984, which is the Family Courts Act. Now that act is specifically for matters relating to the family matters between husband, wife, child. And it includes marriage, it includes money, it includes maintenance, it includes child custody cases, it includes even rights over the assets or marital assets, matrimonial, everything. A whole gamut of all is there under the Family Courts Act. The family courts have been established at places which are metropolitan places where the population is 1 million and above. The Family Courts Act, those of you who are students and who have studied will know that there is a mandatory counseling that takes place in family courts, because that is what the law says. The aim and the object of the Family Courts Act is to ensure that there these things are done gracefully, mediate, try and preserve the marriage, and only in extreme cases go in for these things. So, this family, the very fact that in 1984 the new enactment came, itself shows that how these laws of marriage, divorce, child custody, maintenance, alimony, division of property, etc., came up. One last thing before I wind up. As the law, as years passed by, law did not progress, or those amendments were not made to that effect, or most of the points were not covered by the lawmaker. Today, we don't have a ground which is irretrievable breakdown of marriage. Parties who are lived separately for 15, 20 years still have to prove cruelty, still have, if the other spouse does not agree, still have to prove cruelty or desertion or something. They can't go and say that, listen, your lordships, 20 years we are living apart, 15 years we are living apart, 10 years we are living apart. What is there? Is there in the marriage? But no, the court says either you go by mutual consent under section 13B, or you go under the fault theory, you prove your point. So this is one of the suggestions that I would like to say and use this forum, that irretrievable breakdown of marriage where parties are living together, not a possibility of them coming together. You can't just keep on whipping the dead horse and not get any of these things which are there. And more importantly, that one has to see is that today a practical call has been to be taken, because for the first time in the 2005 protection of women under the Domestic Violence Act, the courts have recognized and given credence. I would not say recognized, but have understood that there is a concept where you don't need to be a husband and wife, but there could be a live-in relationship. And if the woman who is in a live-in relationship is facing some kind of violence, or there is any kind of torture that is committed on her, or there's no money given to her, I don't think so that the courts are going to say, okay, but you're not wife, which is what they were doing. Okay, you're not the wife, you have nothing, you should have thought about it. Now suffer. Courts are saying we can't take such a call. We have to accept that today's society is changing, the social structure is changing. People want to get into a live-in relationship, but that should not leave, especially the woman, helpless and remediless. And that is why the 2005 Act came into existence in 2006, which is the Protection of Women from Domestic Violence Act, for any person in a domestic relationship. All other enactments are any person who are married, but this act talks about any persons who are in a domestic relationship are the ones who could be considered there. And you guys have to now tell me, because you are the ones, you are the younger generation, what do you feel about your reform civil code? Do you think that we should end all this Hindu, Muslim, Christian kind of stuff? We have one penal law, correct? If you commit a theft or a man commits a theft, the punishment is the same. So why different laws? Well, how can we ensure that the traditions and the historical evolution is not compromised, but a practical approach is given? This is all this that you need to debate. So in kind of conferences like this, I not only want to share what the law is, because I'm sure that you can read in the law books and you can get it also, but also make you wear your thinking caps and think is, how can you bring about changes in the existing structures that are there, which will consider the changing factors in the society, make it more compliant that way than the way it is here. So I think I have been able to stick to the points that I have said there, but I'm open to questions and I'm open to any discussions. But more than questions, I would want to know your views on this.
Yes, ma'am. Thank you
Thank you
very
so
much.
much. Thank you so much.
Yes, ma'am. That you stated one of the judgment you must be aware about. When the lady having a extramarital affair and she's approaching court. So then court is saying you already have committed offense, not and then you are coming out to us. So that was again I would say good remarks by the judges in that
Yes,
particular case, recent ones.
yes,
And then you are seeking recourse. So that was
yes.
Sumit, over to you. Sumit.
Good evening, ma'am. Very good evening.
Yes, please. Who's speaking?
Ma'am, this is Sumit.
Hi, Subit. I wish I could see you.
Uh, Ma'am, right now I'm in my home, so that's the reason I've turned
Okay.
I've turned
Yes,
the video.
Subit. Tell
Ma'am,
me, Sumit.
what my point is, ma'am, like you asked my opinion about uniform civil code. Ma'am, uniform civil code, like within, like ma'am must be aware, there is a community in Himachal Pradesh where a woman get married to two, three brothers so that so that the property is not divided amongst the family, and the tribal have their own set of traditions. So something which is not acceptable in the entire in which is not supported by the own community as well, how can that be implemented across India?
So it is my question, and I'm neither talking for it or against it. What my question is, it is not one community or one sect of the society which decides what the law should be. The law should be for the betterment of the larger good of the people. The law should be enacted to ensure that there is civility and the law changes according to the society. I'm very often asked this question in all my interviews, etc. What is it that brings about? Does the change in law bring about a change in the social structure? Or is the change in social structure reflected in the law? And that's the time I realized that it's both. Like earlier we had no, I mean, just to give you some very old legislation, we had to have a widow remarriage act. Can you imagine? A widow could not get married for no fault of hers, or remarry, if I would may use that word, because the law would say, oh, I mean, the customs and the society would say, no, 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 you're a widow, how can you get remarried? So a legislation had to be brought about where the widows could get remarried. Earlier, women were not allowed to own property. They were not allowed to have their income or keep anything. Everything belonged to the husband or the husband's family. The law was brought about when married women's right to property came up. Hindu Succession Act came up where the women were given inheritance. So, amendment to the Hindu Succession Act happened where girls are now considered as co-partners, and they have equal rights in the ancestral joint family as the men or the boys who first had it. So all these, why have these changes brought about? The changes have been brought about only because that is the need of the hour in the society. So, Sumit, your contention ki this is what is happening, and that is why such a thing should not happen. You may be right from that point of view, but is it for the larger opinion or good of the people around? Today, why did the Muslim women, I'm asking the question, why did the Muslim women have to go to the Supreme Court to get the triple talaq banned? Correct? A Hindu woman has to struggle in courts, or the Hindu man has to struggle in courts, and here, and this I'm not talking about religion. We are not talking about religion at all. We're talking about what the distinctions are there. But a Hindu, but a Muslim person could pronounce triple talaq. Triple talaq is instant triple talaq. Okay. Today also triple talaq is there, but we'll do that session whenever we have next time. But instant triple talaq was banned by the Supreme Court by its judgment, because such a practice, such a thing was very oppressive for a woman. The woman was left penniless, shelterless, and she could do nothing within law because that's what the law was there. So who came to the rescue? The courts came to the rescue. And now instant triple talaq is an offense. It's a criminal offense. This kind of changes the law brings about serves as a deterrent for any ill that is likely to happen, but also gives a positivity for the betterment of the society in general. That's what the law is meant to be. We can't hear you, Dr. Gupta.
Yes, sir. Next, Anand Kumar.
Uh, Good evening, ma'am. Thank you very much for a wonderful session and
Thank you.
lots of insight. Uh, with regards to UCC, I have got 2 points. One, even our constitution mandates that UCC should be applicable in India. One. Second, everybody who's a citizen should be ruled by one kind of uniform law. However, my understanding is that this issue has got more to do with politics than to anything else. Until unless the legislature decide that they will have to overcome and bite the bullet, it will be a question which is the academic discussion which will continue. Thank you.
Yeah, it is. So we are not into the politics. We are all lawyers. We are students of law. We are talking about legal matters. We are talking about the social structure. Now, neither of us are interested in any of these issues which are there. We, as a society, we have to debate. We have to bring about changes in law. And if we debate and become opinion makers and try and influence the people who are in the legislature who are going to legislate, and if it is betterment of the society as a rule, why not is the question. And I'm not saying yes or no. Of course, there is today no structural uniform civil code. We don't know what the government is trying to do. We are not politically inclined either which ways, for or against. We just have to look at it from the point of view as students of law, and what is the real reason for us, or what is the need for a uniform civil code.
Good evening, madam.
Yes.
Thanks for the insightful session, madam. And I have a one question, madam, to you. If your wife finds that husband is an impotent because he was not able to consummate the marriage, can she invoke sections 12 under the ground of impotency, declaring marriage void, and
Yes.
same time section 13 under the ground of mental cruelty, dissolving the marriage? Can she invoke both the sections together in the same petition?
Yes. I'll tell you why. Now, if you go to see that your non-consummation of the marriage, you can use that. But in the event you are not able to prove that, because ultimately at the end of the day, when there is a contest, then the question happens, or the question that arises is that what is it and how do you prove it? So if I am not able to absolutely go and prove that, the fact that the marriage is not because in an annulment you have to prove that there is impotency on the part of the husband or the wife, as the case may be. It could be physical, it could be legal impotency, it could be relative impotency, and so on and so forth. But if you're not able to prove that, then if the fact of marriage not being consummated is accepted, that amounts to mental cruelty, because healthy sexual relationship is the basis for which a marital relationship can thrive upon. If that is not available, then what is the point in keeping the marriage?
But can the court declare marriage is void along with the dissolution of marriage?
No, madam, what happens is that for a divorce, you have to do it after 1 year of marriage. You can't file for divorce before 1 year of marriage on the grounds of cruelty. But if you want to invoke the provisions of court prior to 1 year from the date of marriage, the only option left for you is to go for annulment.
We will invoke the section 14 of Hindu Marriage Act,
which are extreme circumstances, okay? Which are extreme circumstances. But my experience as a lawyer tells you that very few courts have the thing to invoke section 14 of the Hindu Marriage Act to bring about exceptional hardship that is caused because of this. But in reality, it becomes difficult.
Thank you, madam.
Pleasure.
Ma'am, on behalf of organizing committee, I extend a sincere gratitude to you, ma'am, for such an enriching session today. We are truly thankful to you, ma'am, for not only accepting the invite, but also taking time to guide and inspire all the participants. Thank you, ma'am, for coming and joining us.
Pleasure. Thank you for inviting me and giving me this opportunity to chat with all of you. Thank you.